Hi, everybody. Welcome back. I got to come up with a cool name for Webinar Thursday because it just really doesn't have a ring to it. But we are so excited to have you join us today for our lunch on the employment rules. So I am so excited to have my panel of guests. We have Dr. Steve Conway, who is here, who's also a healthcare attorney. We all have Joseph Gumina, Erica Reib, and Kelly Kuglitsch, who are here to share their knowledge and tell us what are our responsibilities during these crazy times. So without further ado, I am turning it over to them.
Good morning, everybody, or this afternoon, I guess it's wherever you happen to be. So this is, for a lot of you that joined us before, this is a repeat. So we had so many questions. We had a lot of energy with the first presentation we did. We said we need to come back. So I'm so happy to have our panel come back and help us. So what we've done in the meantime is taken all your questions, look through them, group them up, and we're going to provide a lot of information back and forth on that aspect from the previous questions. But if you have new questions, make sure you ask them as we're going along here, and I'll pop them up and we'll bring them into the discussion for today. Interesting too, since the first time we did this program, we were talking a lot about the employees and all the different things happening with that, with some of the sick leave and all the different aspects going on with the new FMLA that now affected a lot of us. In the past, it was always if you were under 50 employees, this is stuff that really wouldn't be a factor for us. But now there was this new change, and all of a sudden we were dealing with it. But again, new regulations, new things came out, and you're going to see that there's some exemptions in there. So that's going to, I think, take a lot of the pressure off of those, a lot of the questions, a lot of the answers that happen with that. So again, I think, Erica, are you going to handle that part again today?
I am. We're going to talk about healthcare providers right away.
We're starting with that?
We are.
Excellent. All right. So I do want to say thank you to the attorneys on here. They're all from O'Neill. I don't have the full thing. Hang on. I'm sorry, guys. I don't have.
O'Neill, Cannon, Hollman,
O'Neill, Cannon, Hollman, DeJong, and Laing. So it's a phenomenal firm based out of Milwaukee. And again, I'm the executive director of the Chiropractic Society of Wisconsin. We started this out as basically helping our members in Wisconsin. And the members of this law firm said, we'd like to help. So they actually donated all their time and their energy into this to helping us. But we also realized this was something that was going to affect chiropractors across the whole United States. And they agreed to do this thing across the whole United States. So I cannot say thank you enough to you for doing this for our profession. It's greatly appreciated. We also want to thank the ChiroHealthUSA, Christy, Dr. Foxworth, and all the great people at ChiroHealthUSA for actually moving this to their website that could handle all the different aspects of it. So thank you to them. But we'll move forward and let's go. Erica, are you starting out then?
I am. So
all right, let's go.
Hi, everybody. Thanks for coming today. So as Dr. Conway mentioned, we took all of the questions that you had asked over the last couple of presentations and since then and tried to combine them. So just kind of a quick disclaimer, those of you who've been to the other presentations have seen this before, but this webinar is all about a federal law, the Families First Coronavirus Response Act, and I think Kelly may talk a little bit about the CARES Act as well. This is for general information purposes and it does not constitute legal or professional advice. Your state laws may differ slightly on this, so before you make any decisions, please contact your local counsel. And this presentation does not mean I or our firm or Joe or Kelly or our firm has an attorney-client privilege with any of your practices or individually. So as I mentioned, I wanted to talk first about healthcare providers because I think since our first webinar that we gave on this, we talked about, healthcare providers would be exempt, but we didn't know what that meant. And then the BOL came out with a question and answer, and they said that, for the purposes of employees who can be exempt from paid sick leave and expanded medical leave, a healthcare provider is anyone employed at a doctor's office and a number of other things. I think when I first talked about this last week at the unemployment one, I said that, I was a little concerned about, how expansive that was and how DOL and other things would be exempt from it. I am still a little concerned about that. This is in the final regulation that the department put out earlier this week. However, there is also some introductory language to the regulations that says that this is not meant to include just diagnosing medical professionals, but it's also meant to include healthcare providers who are capable, or individuals who are capable of providing healthcare services necessary to combat the COVID-19 public health emergency. So my concern is that if you, as a chiropractor, apply this to your practice, a court or the DOL could say, well, if you're not providing COVID-19 related care, are you really a healthcare provider? I think they could certainly say that for, your receptionists and your your non-provider employees. So while I think that this exception potentially applies, I think there is some risk to applying that. And I also, if you're a small employer, under 50, which I think a lot of you are, I think that that's an exemption that may have more traction for you, and you can be able to use as well. Sorry, I failed to mention this, but Joe and Kelly and I are going to kind of do this together. So if Joe and Kelly have comments on this, please.
Yeah, I think, the Department of Labor has indicated that even when it's clear that the exclusion applies for a particular business or entity, that they employ healthcare providers, that they are to use it judiciously, meaning that just because the exclusion exists doesn't mean that you have to or should be exercising that right, which in my mind leaves open the door for the Department of Labor to argue whether it should be applied in the first place by any particular employer. So as Erica indicated, caution needs to be applied in claiming this exclusion for any particular employee. And also, I think Erica mentioned that there's been some letters written by certain senators, Department of Labor, to kind of close down or limit this exclusion, because the question is, should it apply to the front desk receptionist? And that's not clear at this point. A fair reading of the law would say, yes, it does apply because it applies to any one employee. But whether it should apply or whether you should apply it to all your employees, I believe is still an open question. And we may see further guidance from the Department of Labor on this issue.
And if I could interject too, because sometimes we have new people listening on this one that may not have heard us 2 weeks ago or even last week. This is the third week in a row we've been up. So we, again, appreciate that. So again, this came out as part of, was it part of the care package, or what was this part?
This is part of the Families First Coronavirus Response Act.
So when this first came out, it looked like all of a sudden all these employers, like chiropractic offices that had less than 50 employees, now would have to follow rules of allowing their employees to have paid sick leave. And they also had the new FMLA regulations applying to them, which when you're a small business owner, like most of the chiropractors we have here, that was a major concept or major issue for them to deal with. And so that brought a lot of the questions that we had in the very beginning. And then since then, DOL came out with new guidance, or not information, right? Again, the terminology is a little different on that. And showing that there is this potential exemption. You have it on the slide up here where it says anyone employed by any doctor's office, which is that aspect. But we're trying to, and I hope everyone understands, when new laws come out, everyone's doing their best, right? There's no judicial references. This hasn't gone in. There's no case law that you can work with to give you reference around this, to give you more clarity. And so at the very beginning of these things, we're all doing our best to tell you the information as best we can. Is that clear? Is that fair to say?
Yeah, that's fair to say. And it's fair to say that, the chiropractors participating in this webinar today potentially can take the position that under this part of the FMLA, that they are healthcare providers, that their employees are also healthcare providers as defined by, this very new law. I mean, it's only weeks old, and that they can exclude their employees from having to provide paid leave. However, Stephen, as you indicate, there's no, other than vague guidance from the Department of Labor, there is no judicial analysis of this law. There's no judicial application of this law to chiropractic offices. And so it's an open question of whether chiropractors under this part of the law can, one, claim the exclusion, and how deep in their office can they apply it? can they apply it as it's stated? There's parts of the law that we thought were very clear. For example, who is a child care provider? And the DOL then turned it around and says, well, no, it doesn't really mean that. It actually means something more. You can actually have family members who provide regular care to be child care providers, even though they're not compensated for those services. So what you see on paper in black and white may not be the reality of how the law is interpreted or applied. And so that's the caution that we're giving to our clients and to the people that we're presenting to at the various webinars that we're presenting at.
I appreciate that. So basically you're saying, here's what we know so far. We can say that obviously in our chiropractic offices, we have like chiropractic technicians, we have people that provide healthcare services as ancillary services in our offices. We feel very comfortable with those. Where it may be slightly gray would be maybe your receptionist or your insurance CA, someone that does those more clerical type work. But looking at the black and white up here, it just says anyone. So they at least have something to stand on. And as more information comes out, we potentially can provide additional information if they clarify it down to only specific people. Would that be fair, or?
I think that's fair. I think it's just fair to say that taking that position is not without risk. It's
right.
Not clear cut. It is gray. And as I advise a lot of our clients is, we'd like to try to give you advice where you're not the first test case in the country on this issue. So let's, be conservative in your approach to it and how you apply it. And what we'll be talking about in just a few minutes is, we think that maybe your better exclusion or exemption is to apply a small employer exemption and stand under that rather than this exclusion. Maybe a better route.
Excellent. Okay, thank you.
All right. So moving to the next slide. So who is a covered employer? I know there were a lot of questions about, are chiropractors covered under the FFCRA as employers? And the answer is yes. Broadly, it covers all private sector employers with fewer than 500 employees.
So which means, as Stephen indicated, that it now includes small employers. So it includes employers that have never had to deal with or administer FMLA leave or any type of mandated or statutory required paid leave, and now they're drawn into the fray here, having to administer leave provisions that they for employers that have never dealt with these types of laws, which are complicated. They're burdensome to administer. They're burdensome to comply with. So we have a whole group of new employers that are drawn into this. So there is an exemption for those employers, but it's not an absolute exemption. So Erica, if we can move to the next slide.
Okay. Are small employers exempt from the FMLEA and EPSLA?
And just so everyone's clear what those acronyms means, the FMLEA stands for Family Medical Leave Expansion Act. That is the new leave entitlement that was amended or now made part of the Family Medical Leave Act that was added by the Family First Coronavirus Response Act. And the second part that was added under the Families First Coronavirus Response Act is the EPSLA. That's the Emergency Paid Sick Leave Act provision. And that provides an employee up to 80 hours of paid sick leave for 6 different qualifying reasons. But to answer the question on this particular slide, are small employers exempt from these 2 paid leave provisions under the FFCRA? And the question is yes, but only under certain circumstances. And what the employer has to show is that by providing the leave, that providing such leave would jeopardize the viability of their business as a going concern. As we mentioned a few weeks ago, we believe that this is a high standard for any employer to meet. You basically would have to show or prove that by providing the paid leave, the 80 hour, up to 80 hours for any particular employee, that it would cause you to go out of business. So recently, and then Erica, with regards to this slide, I'll let you read the question. And we'll
oh, sorry. What does a small employer have to establish in order to claim the exemption?
So since our last presentation, the Department of Labor has come out with additional guidance or regulations that has kind of defined what it means, where, under what circumstances would employer, their business be jeopardized, or the viability of their business be jeopardized by providing paid leave. And the DOL has indicated there are three circumstances or things that the business could document, or first have to determine and then document exist for them to claim the small employer exemption. The first one is, just as I mentioned before, that by providing the paid leave would result in the business expenses and its financial obligations exceeding the business's available revenue and cause the business to cease operating. Again, that's a pretty high standard, because there's a lot of circumstances, a lot of factors that would factor into a business or any entity going out of business. And it wouldn't necessarily be one thing, but it could be, that making or being obligated to pay the paid leave for somebody who's not working is the proverbial straw that breaks the camel's back. The second reason that an employer can find or document that that would qualify it to claim the exemption is if they could show that the absence of the employee who's requesting leave would entail a substantial risk to the financial health or operational capabilities of the business because of the employee's specialized skills, knowledge of the business, or the employee's responsibility. So in other words, you're basically talking about a key employee where you couldn't operate your business because either one or more employees was unavailable to work because they were exercising their rights to paid leave under these two laws. And finally, the last basis for an employer to establish viability is that they're just not sufficient workers who are able, willing, and qualified to perform the work that would be provided by the employee taking the leave. And I think this third provision is by the Department of Labor, the way I read this, is it basically, I think, it has to be taken on a case-by-case basis. So if we can move to the next slide.
Could I ask a question on that one too, or maybe it's on the next slide too? So in a lot of these small offices, oh, maybe you're going to answer it here. I'll let you just keep going. Sorry.
Yeah, Stephen. Yeah.
So we were given a couple of scenarios in.
Yeah, you're very. Yeah. Stephen's very perceptive, and he catches the issue, and we're going to point out the issue to you with regards to. I think overall the leave claiming the exemption can't necessarily be done prospectively. As we indicated a couple of weeks ago, we believe it has to be done on a case-by-case basis. However, there's always exceptions to the rule. So let's, Erica, present this question.
So we got a couple of questions, and I think probably about some of your individual practices and would the exception apply for you? And one of you said that you had 3 employees and having one of them on leave would not make your office viable. And could you then claim the small business exception?
Yeah, so, I think under this fact scenario, we have a very small office, 3 or 4 employees. If you lose any one of those employees, it makes operating your business very difficult. We think under those circumstances that you probably could prospectively, today, or this law took effect on April 1st. On April 1st, you could have put a flag in the ground and said, we are so small, everybody in our business is so critical to the operation of our business. If we lose any one of you, we can't operate. Therefore, we're not providing any paid leave under any of these new laws because we are claiming the small business exemption. And so I think that's that's possible. Again, you would have to establish, and determine and make a written record that that is the case, and maybe a little written description of what each employee does and why their function in your organization or for your business is critical, and not having them would cause you or cause your business to be unable to operate.
So,
Go ahead, Erica.
Sorry, the 3-panel is something we haven't done yet, so we're still working out the kinks. I think this falls a little more clearly under either the second or third option under the small business exemption, that either, these are key people that without their knowledge and having them there, you can't function, or the third one that says that, if you physically don't have enough bodies to work if they're not there. So I think this example, if you have 3 employees, it's not necessarily a financial burden that, your business would have to shut down if you provided this leave. It's more of that their skills and them physically being there, that there aren't enough employees to do the work.
And they don't have to hire new employees, right? So let's say I have 3 employees, one wants to leave, and that makes it tough for me to work. Let's say it's a receptionist, which there are people out in the world that I can get a receptionist. I don't have to pay for the person off and then bring another person in to replace them. So I'm paying twice. That I could still do this exemption.
Yeah, that's good. That's a good question, Stephen. And my answer to that would be no. And the reason is because the employee who's taking the leave in the first place has rights to restoration to their job. So you wouldn't necessarily, under these laws, require an employer to go out and hire a new individual or someone to replace that individual, because it just adds to your cost of operations. Exactly. Right. So that would be very difficult.
Okay, good. Thank you.
And so we had essentially the same question, but instead of having 3 employees, the employer now has 10 employees, and they also wanted to know if they could claim the small business exemption.
And we think, as compared to the previous question where the employer or the office only has 3 employees, we think as you get, talk about having more employees, the question becomes more difficult as to whether the small employer exemption applies. I think under these circumstances, I think that the exemption cannot be claimed prospectively. So, if you were a chiropractic office with 10 employees on April 1st, you couldn't on that date say, well, I am claiming the small claim exemption because all of you are critical. I don't think you would be able to do that. I think you would have to make a case-by-case determination as to each employee as they are claiming entitlement to leave, whether you should be claiming the small employer exemption. Because it's possible that none of your employees would claim leave or take leave. So it would, so you don't want to state out front that they are denied the opportunity because you're trying to claim the exemption that they can't take the leave. Erica, did you have anything to add?
No. I have one question on that. Is this anything they have to do proactively to set this up, or does this kind of go in place when, let's say, an employee says, I want to now leave, and you say, no, I'm exempt? So is there a timing with this that they have to set this up, or?
Yeah, that's a good question. With regards to the timing, it's going to have to, the timing occurs at the time that the leave is requested by the employee. So the employer is going to have to make not only a legal decision, but a business decision at that time. Am I granting this leave to this employee? Now, a lot of times I tell employers is, sometimes the business decision trumps the legal decision. You have to do what's best for your business, and if there's legal ramifications because of it, make that decision what's best for your business. And if because of business concerns, you think it's best for you to claim the small employer exemption, then claim it. And if that's true, tell the employee why you are claiming the exemption. Maybe it's because of their skill or knowledge about the business or what they do that is a critical factor in your ability to operate. Or it may be, as at this point, revenue is down. The number of patients that we are seeing is dramatically down. And we don't know how our revenue forecast looks for the next 30 days. So right now, we can't afford to give you paid leave. So, that could be another basis. So whatever the reason is, what are, of the 3 reasons that we just discussed, that will qualify you to claim the small employer exemption, I would advise you to make a internal memo indicating that on this date, Jane Doe, your employee Jane Doe, requested paid leave under the Emergency Paid Sick Leave Act, and for this reason, we are denying the request for leave. We are claiming the small employer exemption because, and then provide your explanation why, and keep that as a business record. So in case the employee would challenge you later on, or the Department of Labor would challenge you on that claiming the exemption, you have a business record made at the time that the decision was made as to why you believe the exemption applies. And at that point, you can take on that fight.
I just want to note that at this point, that is all internal documentation. You shouldn't be sending anything to the DOL or anything like that. So, you can be thinking about these decisions now, kind of, if X employee wanted to take off, is that somebody I could allow? But, that decision may have to change in the moment, and you do need to document it, but, keep that as internal documentation.
Those are my 2 questions. Like, what type of documentation they need to have? And should that probably go, and the other ones, do they have to report it to anyone? So you've answered both those questions, which are excellent. And that paperwork, should they put that like in their employee file? Would that be a good place to put it? Or would you put it like in your compliance manual, or?
Yeah, I would put it in both places. I think it's important to put it in both places. I would put it in the employee's file, and I would keep a compliance file relative to these laws and kind of a master file. And
then just have it in case somehow the employee turns it in, something like that, you have this documentation ready to go.
Yeah.
Do they need any references at all? Is there any references that they should use with that? Or is it just like citing this or that? Or is it just more just have that in there?
Well, I think citing to the exemption as it exists in the regulations, and to the extent that they need legal assistance with that, they should seek that, and you can make the cite, although it's not necessary.
Not necessary.
The exemption's clear. And we know that the participants in today's webinars are not lawyers. They do not know the specific reference to the specific regulation, so to be able to cite it, just to be aware that you're claiming the small employer exemption under the Families First Coronavirus Response Act, I think would be sufficient, and then provide the reason why. And the 3 reasons, you go back a few slides, not that we have to. But that is right out of the regulation. So you could cite, say we're not providing the paid sick leave for this reason, and you can copy that verbatim from the slide that's entitled "What does a small employer have to establish in order to claim the exemption?"
Perfect. Thank you.
Okay, so moving on, because we have a lot to get through still.
Yes.
So the question is, if we have 6 employees, 4 of whom have children at home because of COVID-19, their schools and daycares are closed, can we furlough some employees?
The answer is maybe, and it's probably yes, but caution is advised under these circumstances. These laws do provide for protections to employees that prohibits an employer from discharging or disciplining or taking any other manner that would discriminate against an employee who takes leave. And it's unclear whether somebody who says they might take leave or could take leave, whether they are also protected from discrimination or retaliation. But I would say for these purposes, sitting here today, you should assume that that is the case, and don't furlough employees because you're afraid that they may take paid leave or you might have to pay them for paid leave. That would not be arguably a valid reason to take leave. But at this point, we don't know. It may be, or they may not have protection of the law for that type of retaliation or discrimination. Again, there's no judicial cases to interpret these laws at this point, so it's unclear. However, if there exists a financial or business reason to furloughing employees without consideration to their entitlement to any type of paid leave, then yes, it would be lawful to furlough the employee. So again, make that decision that benefits your business. So if it's a good business decision to do so, then do it. And always give thought or consideration to legal considerations. give thought to what's best for your business.
Yeah, and I also wanted to put in a note there that, in addition to discriminating against people based on their need for leave and the fact that that may be illegal under this law, I'd also, kind of caution you against, getting yourself into, and this is a little bit outside this kind of sex discrimination waters where, you have some male employees and some female employees. And if the assumption is that the female employees are the ones that are going to take this childcare leave, and those are the ones that are furloughed, that could raise some litigation concerns later on.
Or even to deny the leave, saying, well, you have a husband that can take care of the kids.
And we have a question like that in the comments right now, actually.
Yeah.
And the next question is about working. We'll actually get to that comment in the next slide.
Yeah.
Okay.
I have one thing to go with too, because a lot of our people listening have not really furloughed someone. This is something. This is kind of a new situation for them. They basically have either hired someone or terminated someone, right? But to actually, this is maybe a new concept for them. So, is there any special things when you're saying furlough? Is that maybe explain that just a little bit for them?
Yes. Yeah. Furlough. You distinguish it between a furlough and a layoff, and at least that's the way I distinguish it. And a layoff is usually, because of business necessity, we are laying off, we are terminating your employment. We no longer have a need for your labor services. A furlough is a layoff, but it doesn't result in termination. So we are furloughing you for X weeks, and then at that point we will be bringing you back to work if conditions allow. So usually you can think of a furlough as a temporary layoff with the expectation of recall.
Okay.
And Kelly, I don't know if you want to talk quickly about any kind of benefit implications of a furlough or temporary layoff versus a termination.
Yeah, so I think there could be more distinction to keep in mind on the employee benefit side of things. 401k plan, for example, if 20% of your employees cease working, whether you've called it a temporary furlough or employment termination, the 401k plan could actually be deemed to be partially terminated, to use the IRS's terms, which could mean that all employees under the plan suddenly become 100% vested in any employer contributions if they were not already vested. So there can be some sort of separate employee benefits aspects to having employees stop working for you, just to keep in mind and add to your list of things to think through if you are in that situation.
Okay, so moving to the next slide, what if employee can work or telework even though the employee has children at home because of COVID-19? Is the employee entitled to leave? And Joe, based on the question in the comment, we also should talk about, if an employee has another individual at home that is teleworking, can the employee still take leave to care for a child that's at home because of school or daycare closure?
Yeah, so there's a qualifier for an employee to take paid leave, and it's really that it's their inability to work because of the reason, and this basically comes into play for leave that is allowed to take care of a child because the child's school is closed because of COVID-19, or the child's care provider is not available due to COVID-19. So the question is, if your employee's child is at home because of their school is closed, do you have to give them paid leave? And the answer is no. The question really is, can they work or telework, or basically, can they work from home? If they can't work from home, and I assume for most of the participants in this webinar that many of their employees cannot work from home, that if they have children to take care of and they have to be home to take care of their child, then they would be entitled to paid leave. But if they can, even though they have a child home and they can still work, even though that child is home, they would not be entitled to paid leave. And I give the example of, it's different circumstances if your employee's home taking care of a 2-year-old versus a 16-year-old. A 2-year-old needs probably constant care, constant watching, and is probably hard or almost impossible for an employee to get any type of work done while trying to watch a 2-year-old. I can't say the same is true for a 16-year-old who's home from school, is either going to be outside somewhere or in their bedroom playing video games all day and rather not be bothered by the parent. I think you have to have, if your employee is able to work from home, I think you need to have a conversation with your employee about whether they can actually work. And if they can, then I would promote them to work and not to take paid leave, because that doesn't help your business necessarily to pay somebody who is unable to perform services.
Right, but at the same time, I would caution against not providing them the leave because they have a spouse who is teleworking. That's a consideration.
So I would like to jump. There is a DOL in the DOL guidance talks about being able to work or telework because the other parent, if there's another parent at home. And the employee does need to be required for care. So if there is another co-parent, co-guardian, or usual child care provider that is available to provide care, they won't both get leave. So, the employee should certify in their need for leave that they are the ones that are needed to care for the child. So if the husband is at home teleworking and can't provide care because he's teleworking, and the employee then needs leave to care for the child, it's essentially they need to say that they are needed for care. So there are some co-parenting issues there, and it depends a little bit on who is going to be needed to care for the child.
Yeah, an important point here is, as an employer, unfortunately, you really can't argue with your employee if they take the position that I can't work, or I have to provide care for my child, and my husband has to work, or my wife has to work, whatever the case may be. That if they say that they can't work, we'll have to accept that certification from the employee and grant them the leave.
Okay, so this was a question presented that somebody had an employee who had been absent for a week, and they wanted to know if they could ask if she had been treated, tested, or diagnosed with COVID-19.
Yeah, and the answer is yes, absolutely. In fact, you'll need that information to claim the available tax credits that Kelly will be talking about a little later. The Americans with Disabilities Act permits an employer to ask an employee medical questions if the questions are job related and consistent with business necessity. And under these circumstances, asking such a question about an employee, whether they've been tested, treated, or diagnosed with COVID-19, would be job related and consistent with business necessity. And HIPAA just does not apply when the employer is acting as, or the business is acting as an employer. Under those circumstances, it doesn't apply. And again, talking about the business decision versus the legal decision.
I just want to jump in. That's absolutely correct. HIPAA does not apply to the employer asking that question. It will apply if the employer, instead of asking the employee directly, were getting information from the company health plan. That would be permitted by HIPAA. As long as it's the employee providing the information directly about themselves to the employer, that's...
Okay. And so then in a similar question, somebody was asking about what the employers can ask employees related to their COVID-19 diagnosis or symptoms.
Yeah, and this is just a follow-up from the last slide. Basically, here's the list of what you can ask or information you can gather from your employees. You can ask for a positive test result or other diagnosis. You can ask for if they have symptoms of COVID-19. You can ask them if they had close contact with anyone in the last 14 days who's tested positive. You can also ask whether they've been asked to self-quarantine by a physician or health official within the preceding 14 days. And lastly, you can ask them if they travel to any geographical area, either internationally or domestically. If you knew your employee was traveling on the East Coast, you can ask them, were you in New York City, in the last 14 days? And, based on that, You can make a decision whether, you want them to be in your place of business working under those circumstances, or whether they should be home self-quarantined for a period of time.
Okay. And then there were some questions about, if schools are closed because of spring break or Easter break, coming up this weekend, does the Emergency Paid Sick Leave Act and Emergency Paid or Emergency Family Leave expansion still apply during that break time, such that the employees could ask for leave under those laws?
Yeah, and the answer again is maybe or perhaps. There's no DLO guidance on this issue. There's obviously an argument that the school would not be closed during this time, and the employee would have childcare responsibilities during this time, without the impact of COVID-19. But there's the other question is the other issue to flip the coin is the schools remain closed. They still remain closed for reasons related to COVID-19. And as long as they remain closed as a result of COVID-19, whether they would have had break or not had break, the person would still be able to exercise their right to take paid leave under these circumstances. So this is kind of again, as Stephen indicated earlier, this is one of these gray areas. But there's an argument that can go both ways.
Okay, so I know that there was some confusion about, these laws came out in, I think, a mid-March bill. They went into effect April 1, but can we apply these leaves to leave taken before April 1st? We had an employee who was out in March because they were sick. We had an employee who self-quarantined in March because they were sick. The answer is no. These leaves apply only to leaves taken on or after April 1st, currently through December 31st of 2020. So anything that they took prior to April 1st, this leave does not count towards that leave does not count towards their entitlement under these two expanded leaves, and you would not be able to get tax credits for any amounts paid to those employees prior to April 1st.
I will just jump in though. There is a separate tax credit, the employee retention credit, and it's not related to these paid leave provisions we're discussing. It is another separate credit. It also cannot coexist if you apply for the Paycheck Protection Program. However, it's a tax credit that allows you to get a 50% credit of up to your payment of $10,000 of wages. So therefore, the maximum credit for employee is $5,000. And for some reason, that credit actually applies to wages that began to be paid potentially as of March 13th. So if you were paying some kind of wages to that person anyway, it's possible you could apply that employee retention credit to those wages, just not these paid leave provisions.
Okay. There were also some questions about whether these kinds of leaves can be taken intermittently. Can an employee say, I want to, work on Mondays, Tuesdays, and Fridays, but I don't want to work Wednesday and Thursday. I want to take my 80 hours or my expanded 12 weeks of the FMLA. I want to take them intermittently. The answer is sometimes. All of the leave that they would want to take intermittently for school closures has to be taken with the agreement of the employer. So if you say, I can't, I'm going to give the leave, I'm going to take the tax credit for it, but I can't, run my business if you're only here, 2 days a week, if we're taking this at a, every once in a while pace. You can say no, because the employer has to agree. And that's for care for a child who's home from school. However, if they want to take sick leave because they are experiencing COVID-19 symptoms, they're quarantining because there are concerns about COVID-19, or if they're caring for an individual with those concerns, that leave may not be taken intermittently. The kind of thought process behind that is, if somebody is sick or concerned about being sick, that's not a, every Monday, Wednesday, Friday concern. That's kind of all the time. That leave has to be taken in one large chunk. So sometimes, but in only specific circumstances and only with the agreement of the employer can it be taken intermittently. Anybody else want to okay. We had a lot of questions about, kind of how long, or if, we've decided, I know there, Colorado and some other states, some of those, your chiropractic practices have had to close. But hopefully you get to reopen in May or June or something. And then, if we close and then reopen, we just don't have to deal with this. That's not correct. As long as you reopen sometime in 2020, and the employee has, one of these reasons for leave, they would still be able to use leave through the end of this year, this calendar year. Obviously at this point we don't expect an extension after December 31st of 2020. It's, as everyone knows, a evolving situation, and worst case scenario, this could go into 2021. So at the moment, though, if an employee is on leave, on vacation and returns in mid-April, if they are experiencing one of the 6 qualifying reasons for the paid sick leave or the childcare reason under the emergency expanded FMLA, they would be entitled to that leave. The same as if you close your practice for a while and reopen in May. Again, if they have qualifying reasons for leave, they will be entitled to this leave, again, subject to the exceptions for healthcare providers and small businesses. But these leave entitlements are in place through the end of 2020.
And just to go back to, this is if they don't take the exemption, right? So if they decide to do the exemption, this doesn't apply. And the exemption is a choice. It's not, they can choose to do the exemption or not do it.
Right.
Okay.
And then if they choose not to, and this may be on a slide later, if they choose to give the leave, even if they think they qualify as a healthcare provider, qualify as a small business, if you give the leave and pay the leave, you are then also entitled to the tax credits.
Okay. Thank you.
There were a lot of questions about kind of how do I track this? What documentation do I need? I would track this pretty carefully. I would, ask for supporting documentation. You should have forms for employees to fill out about what kind of leave they're taking, documentation they have to support that. It can be, if a school is closed, it could just be the notice from the school that they're closed. If they're, subject to physician's care and a doctor has told them not to come to work, you should get a copy of that doctor's note to support that leave. Kelly can talk a little bit right now to the IRS, how they're going to handle giving those tax credits. But it's very important that you track these. So, if an employee uses their leave, you could support that in case they question it later. It's incredibly important for the tax credits.
Absolutely. And so when you're thinking about tracking, you need to sort of keep in mind there are kind of two angles to it. There's the labor-related Department of Labor rules for making sure the employee qualifies. Then there's also the IRS or tax aspect of supporting your right to get the tax credit for paying someone any of the new leave categories. So the IRS has clarified that what employers are going to need to retain as far as documentation is documentation showing how the employer determined the amount of paid leave that was paid to the employees eligible for the leave, including records of work and telework, what were the dates of leave taken, detail how the employer determined any qualified health plan expenses. That's a category we're waiting on additional guidance from the IRS, but we believe that there's an additional credit you can take for some of your healthcare costs during the paid leave period. Retain your quarterly forms 941 for your payroll records, and retain any form 7200, which is the form you'll use to request any refund of the tax credit. If the amount you want to claim as a credit is more than that amount you would owe in payroll tax, you file the 7200.
Is there a website that they could go to find these forms? Is there a specific form? And if there is there a website they could go, and is there potentially like a checklist too that they can say, I should have this, this, and this? Does that exist? Or
the IRS has several topical pages and some FAQ guidance on how to claim the credits. I guess I would check out form 7200 first. The IRS has a draft version of that out there. It has instructions that accompany that form, which is going to provide some additional background on claiming it. But the IRS website does have some information.
Yeah. And as far as the kind of general what you give to the employees to have them check off, there is no form like, for FMLA, there are kind of notice and designation forms and those sort of things. The DOL has not published anything like that to date.
Okay, good. Thank you.
Mm-hmm. So there were a lot of questions about, when is leave either allowed or mandated? In our slides from a couple presentations ago, our initial presentation on this, we outlined the 6 reasons under the Paid Sick Leave Act and the 1 reason under the FMLA expansion, why they're allowed to take leave. There were some questions about, somebody is self-quarantining. They are personally worried about having COVID-19, being exposed to COVID-19, and so they have decided they are staying home. In that situation, they're likely not entitled to this leave unless they have been told by a doctor that they should self-quarantine based on their medical condition. Again, that's something that needs to be supported by a doctor's note or something like that. But if they're just saying, I'm worried about this, so I'm not coming to work, that would not make them eligible for this leave. Another situation that's come up is that, somebody doesn't have any symptoms, but has been in contact with somebody and is self-quarantining. Again, that probably doesn't allow them to take leave, again, unless a doctor has told them that they should self-quarantine, or if they do start experiencing symptoms and are then seeking a diagnosis about whether or not they do have COVID-19. And then another one that we have seen pretty frequently is that somebody has a condition that makes them more susceptible to coronavirus. They have an autoimmune disorder or some kind of lung issue where if they got this, they would be much higher at risk for serious complications or death. In that situation, maybe again they need to be advised by a healthcare provider that they should self-quarantine to take this leave. But I think in those situations, that might be a little more common, that a doctor will say, no, you shouldn't go to work and you should self-quarantine. But again, I want to emphasize that this is not just kind of the employee's choice to say, I don't want to come to work because I'm worried.
Yeah, I had one situation with a client where the employee had a serious heart condition, and he tried to go to the doctor to get the doctor to say that he couldn't work because of being vulnerable to COVID-19, and doctor wouldn't provide that opinion. So, you don't always have to accept what the employee says, and you probably shouldn't. They should be supported by a doctor's statement.
So there were some questions about, if we either kind of modify how our business runs or if we modify the schedule. We're seeing less patients, and therefore, instead of being open 5 days a week, we're open 3 days a week. Or, we've gone to, instead of actually seeing patients in person, we're doing telehealth, or we're only sending out supplements. So I think it's important to note that this leave is only available for employees who would have otherwise been scheduled to work. If your office is closed during those weeks, they are not entitled to this leave because they wouldn't have otherwise been scheduled to work. The same applies as if you go from 5 days a week to 3 days a week. They can't supplement those other 2 days with this paid leave because they wouldn't otherwise be able to work. So if you're doing work a bit differently, transitioning from shipping supplements to shipping supplements because you aren't seeing patients, leave is available to employees who are scheduled to work. Kind of what you're doing doesn't matter. But if you've modified your hours, leave is only available up to the amount of time the employee would have otherwise been scheduled to work. Any comments on that, Joe or Kelly?
No comments.
So then there were some questions about how the paid sick leave and the expanded FMLA interact. So the first 2 weeks of the expanded FMLA are unpaid. However, the 2 weeks of paid sick leave act can be used for those 2 weeks that are unpaid. So that's usually how they interact, is that if somebody is out to care for a child whose school is closed or whose childcare provider is closed or unavailable, they would be entitled to both leaves, and they would be used in conjunction. They use the EFM or the EPSLA in the first 2 weeks, and then the remaining 10 weeks of paid leave under the EFMLA. Now,
as you indicated earlier, that the paid sick leave could be taken intermittently by the employee. Yeah, if that happens, they could potentially arguably or use it outside the first 2 weeks of leave under the expanded FMLA. What the law does not allow is employees can't stack paid leave. So they can't take, if they have paid sick leave still available in week 4, they couldn't add to that or stack on top of that paid leave that would be available to them under the expanded FMLA. They can only take one or the other at one at a time. Right,
yeah. They can't say that I get, up to $200 under the FMLA and then add that to my other $200. So they don't kind of add together. The next question is, I have heard that there will be grants available to employers who remain open, even with reduced hours, and continue to pay employees instead of having them file for unemployment. Is that true, Kelly?
Okay, so we're going to switch over to some of the slides I'll be speaking more on, and I'm going to try to go through these, just FYI, pretty quickly so we can try to get through all of them to the end. I've already briefly mentioned that there is an employee retention credit available, but that you cannot get it, remember, if you apply for the Paycheck Protection Program. I do just want to clarify and add that in order to be eligible for that employee retention credit, you do have to have either fully or partially suspended your business operations because of the pandemic, or have reduction in your gross revenues for the quarter as compared to a comparable quarter in 2019. And it needs to be down by 50% in order to start to get the credit. There's some more details around that I won't go into now. And I've listed some other types of grants or loans that are available to employers. And I encourage you to explore and research about some of those. The Small Business Administration website is a really good source of information about those loans. We can go to the next slide.
And I just did want to mention, and Kelly said this, we have about 8 or so slides left. And so if we don't, the slides are available with the information. Kelly has great information on her slides.
I'll just take over reading the questions if you don't mind, Erica. I'll do a speed read here and try to get us to the end. Do these benefits apply also to an employer who takes W-2? And if we are talking about the paid leave, absolutely. Someone taking a W-2 is legally an employee. They are also eligible to the same types of credits. The organization gets the same types of tax credits. Where you have an owner who is not on a W-2, they're self-employed, actually there is equivalent leave available for them and equivalent tax credits in the same amounts. However, those credits are claimed by the self-employed individual on their own income tax return, and it can reduce their estimated taxes. Go on to the next one.
And Kelly, because I know you're going through these quick, but this is stuff if they contacted their accountants or local attorneys that have all this data too, right?
I hope so. Everyone's trying to learn it as fast as we can, right? Okay. But yeah. And then, yes, if we're getting a dollar for dollar offset on our Form 91, then we're essentially net zero on that money. That is correct. For the paid leave that you pay under the new legislation, the IRS's intent is to immediately and fully reimburse employers, eligible employers, dollar for dollar for the paid leave amounts. So the caveat there is just that you want to make sure, claim the credit if you're eligible for it. This is where it becomes really important to document why you're eligible to claim the credit, retain that documentation. We're all pretty confident that once this all blows over, there will be some IRS look back and just checking to make sure all of these tax credits were properly claimed. You want to be able to show that yours were. Here's a question. Would a practice organized as a PLC with only the doctor on he LLC and on payroll be able to claim this? I didn't fully understand the context here. I know we've got people from a lot of different states. There are a lot of different kinds of corporate limited liability entities out there. I presume this is a professional limited liability corporation, maybe with a service arrangement where the doctor's services are being provided to the other entity. But still, either as an employee or a self-employed individual, I would think that yes, the leave amount or the equivalent for a self-employed is available, as are the tax credits. Exempt as in don't have to, or exempt as in don't qualify for the credits. I interpreted this question to refer to the exemption if you were under 50. Maybe you could also look at it as the exemption for healthcare providers, but I think the answer is both. If you are exempt for one purpose, you are ineligible for the other. If you're not providing the leave, you're not eligible to claim the tax credits. That's that slide.
And I think, sorry, just to jump in on that really quickly, I think that the point is that if you give the tax credits, or if you give the leave, you are eligible to take the tax credits, even if you could have claimed an exemption.
Right. And is there interest on the plan loans? I'm going to go super quick because I know we're now just past the time, but the answer to that is yes. Interest still applies on the plan loans, but it is suspended. There's no interest from now through the end of this year, March 27th through the end of this year. So any existing loans are re-amortized, and new ones, interest doesn't start till January 1. Does health insurance have to be upheld by employers during the 12 weeks off? I did not talk about health benefits before when I mentioned employee benefits considerations, but they're very important. If your practice has a group health plan, you really need to check the terms of your plan, because the eligibility terms are all over the place here. Sometimes for paid or some unpaid leave, eligibility does continue. If it is FMLA leave, whether paid or unpaid leave, it absolutely must continue. There are going to be some tax credits for qualified health plan expenses, only for the portion that an employer pays. You might want to consider if you're going to pay in the employee portion of the premium or not. You may be able to get a tax credit for taking on that additional amount as well. And could I alternate employees on and off unemployment? I would say generally yes. Every state's law on unemployment differs somewhat, but we do have the federal pandemic unemployment assistance program. Generally, yes, if you have someone working a week, they're working a week. If they're off the following week on an alternating basis, they would apply for unemployment for that week. Generally, unemployment is applied for weekly on a Sunday, at least here in Wisconsin. And then we're back to the beginning, it looks like, or that's an earlier question. That one's not my slide. And then, yeah.
So these are two of the really helpful web addresses regarding coronavirus from the IRS and the DOL. So I think these are additional places you can go to seek guidance. Again, please feel free to refer to our slides. We did not have time for additional questions, considering we ran over our time with these questions. So ignore this question slide.
And I want to say thank you. I don't think people understand the degree of difficulty it takes to do a program like this, because every single slide you had have so many ramifications, so many different talking points on it that each one could be an hour. And to take it down and put everything into an hour so everyone could understand it, at least get a feel for what's going on, feel comfortable what's going on with all this, has been truly appreciated. Especially this one program here, because these were the actual questions that came from the first and second program. So to take those and respond the way that you did, I truly appreciate all your efforts in doing that. So thank you so much for all of us out in the field for your help.
You're
Christy,
welcome, Stephen. Thank you for inviting us to present this to the members.
Thank you so much.
Y'all have been amazing. And I just want to remind everybody that we do, yesterday we had the webinar on telehealth for chiropractic practice. You can go to the COVID-19 resource page to watch that recording. Make sure you download the white paper, because it is 25 pages of exactly what you need to be doing if you want to offer telehealth. The recording for today's webinar will be posted in about an hour. So if you want to go back and double check everything and listen to it again, please make sure you do that. And again, that link will be emailed directly to you later this afternoon. We are sponsoring some other ones that are coming up. Next week, we're going to be talking about infection control, OSHA, with Dr. Munsterman, and that will be posted on the website later today. First thing tomorrow, everybody will be sent a reminder. So just make sure that you're checking on this resource page. We're updating it daily to give you the most up-to-date information on what you need to know for your practice. Just want to thank everyone for being here today, and hope you have a fabulous and restful weekend. Bye, everybody.
Thanks, Chrissy.
Bye.